Hi, my name is Robert Hetzler from QDROnow.com, and I've been doing a video series on trying to educate either my clients or divorce attorneys in general on retirement benefits, retirement accounts, and all things financial when it comes to divorce. And one of the topics that I think, and I've been teaching through webinars, and I'm building webinars now, but this is a free video series. This is really just to help attorneys understand some of the differences in retirement accounts. So I want to talk today just briefly about a couple of things. One being the difference between defined benefit plans and defined contribution plans. Now, defined contribution plans by definition are where an employee contributes through their paycheck or through their payroll a certain amount of money that comes out each and every pay period. Employers typically will match that up to a certain dollar amount, either 3 or 6%, but usually there's a cap on that. Some examples of 401k or 401ks, 457s, 403bs, which are normally for public employees. 457s are for state and municipal employees. Thrift savings plans, those are for federal employees. But they all have the same name, which is defined contribution plans. So they all act and operate the same way. So what divorce attorneys need to know in terms of defined contribution plans is that they have a lump sum value, meaning they have a value as of the certain date. And your job as the attorney is to find out which part is marital. And if it's all marital, that makes the calculations easier. If there's a non-marital piece to it, then certainly you might have to hire a professional, or the parties can agree, depending on if the records are available. That's usually the biggest issue, is if you have records not available in a case where someone had a 401k 5 or 6 years and then got married and stayed married 20 years, and then they want the calculation done on the earnings for the 4 or 5 years they were married before they got married, and then brought up to today's present value. Obviously you may need a professional should that be the issue. But the bottom line is, when it's a defined contribution plan, you can certainly want to include it in the agreement, the percentage that they're going to receive or certain dollar amount. But the biggest thing you want to think about is you want to make sure that earnings and losses is addressed either by excluding them or including them in the agreement. And what I mean by that is, a lot of times you sign an agreement on April 1st, let's say, says the husband shall receive 50% of the wife's 401k as of April 1st, 2015. Well, what happens when by the time the final judgment is signed, by the time the QDRO's gone through the pre-approval process, then signed by the judge, then ready to be implemented by the plan administrator, we're looking at September here. 4 or 5 months have gone by, and nothing in the settlement agreement says anything about earnings or losses. So 4 or 5 months, it could be a big deal of market fluctuations, especially in an up market. A bear market, certainly going to have the adverse effect. So as you can imagine, that one party or the other is going to take a different position on what they intended the agreement to mean the longer out in time that we're talking about. I had a case one time where someone was to receive $11,000 in 1989 and didn't say anything. The agreement was completely silent on earnings and losses. And in 1989, I was hired in 2010 to do the 401k division. I asked that's a big question, because every QDRO requires an exclusion or an inclusion of market fluctuations or earnings and losses. So in other words, the date that they decided to divide it, they knew that it was worth, say in this instance, this example, 11,000. But it could be 4 or 6 months, it could be, in my example, 10 or 12 years before they actually get around to dividing it. I never recommend that, but it certainly happens all the time. If earnings and losses aren't addressed in there, then you have the potential for litigation again to figure out what was the intent of the parties, because that was completely left out. So in this particular case, the woman had 11,000 coming to her, back in the 90s, and now in the 2000, 15 years later or so, that same 10,000 was worth maybe 75 or 80,000. And so obviously her position was that, yes, of course, gainings or loss were supposed to, or market fluctuations were supposed to impact my portion. And then the other side of the coin was his position is, no, they weren't. It was always supposed to be 11,000. It's her fault if she didn't do the QDRO. So you can imagine, depending on how the market goes, now if the market had gone down and the amount was going to be lower, I'm assuming the the parties may have changed their story a little bit, but the bottom line is it can all be avoided simply by putting in there whether gains or losses or market fluctuations impact and what impact they do have. And generally, they are included. Now, we'll tell you in instances where you have a client that maybe it's a non-financial spouse, someone that's really concerned about money and really has done a tight budget and they need $12,000 and they don't want less, they don't even want more, they need $12,000. There are cases that come out like that. And in those cases, they don't want to bear any risk. In most cases, the market goes up, but we've all experienced the 9/11. We know that there's definitely bubbles bursting all over the place, especially in the last 10 years. So certainly the adverse can happen and the market goes down. Well, if the 12,000 in my example is for sure what that client wants and the other side is okay with it, then simply just put in there that earnings and losses shall be excluded from the equation. And that way the 12,000 is going to come to her, in my example, no matter what it would be. If they had that 12,000 actually gone up and now it's really 15 or 16, she's still only going to get 12. And the participant is going to get the benefit of all the gains and losses that's going to stay in his account. Now the reverse is true, that 12 actually turned out to be 9 or 10. She's still going to get 12 and then the participant's going to eat it. So bottom line is as long as both parties agree on that, that's fine. But generally speaking, earnings and losses probably are going to be included, but you would be amazed at how many agreements, I'd say half the agreements dealing with defined contribution plans is just completely blank and it's not dealt with. So I think the takeaway is that if you've got defined contribution plans, which we talked about are 457s, thrift saving plans, 403bs, and 401ks. 401ks are private employer plans. Those are the ones we hear the most about, but the other ones I named operate the same. They are defined contribution plans. Anytime you have those, you want to include a statement that says whether earnings and losses or market fluctuations are or are not included or excluded from the calculation. Very important. Don't make the mistake of not dealing with it. The only other caveat that I want to say is when dealing with those types of plans, the defined contribution plans, a lot of times parties want to equalize the accounts. Equalizing the accounts means, wife has 4 accounts, husband has 4 accounts, whether IRAs, 401ks, whatever. And they don't want to do a QDRO and pay to have a QDRO done for each of these accounts. That would be 8 or 9 QDROs. They want to add them all up and just see what the total would be divided by the calculation or the agreed to amount in the divorce. And then figure out and take it all from maybe 1 or 2 of those accounts. Say in my example, the wife had a little bit more once you added it up, and so she needed to take out 10,000 from one account to bring it over, or 5,000 from 2 accounts, whichever way it made sense. But try to minimize the amount of QDROs that needed to be done. That's certainly fine. I encourage that. The one thing that you got to be careful of is not to put something like this in the agreement, something that says that the parties agree to equalize X, Y, and Z account. It turns out to be 8 accounts, so the parties are agreeing to equalize all 8 of these accounts, and the parties agree that market fluctuations or gains or losses shall be included in these calculations for all the accounts when equalizing. Well, that's an impossibility. It can't be done. And here's why. When you equalize the accounts, you're basically drawing a line in the sand on that day and saying these accounts are worth this amount of money. And because of that, now the wife, following my same example, the wife owes the husband $10,000 and it's going to be taken out of ABC Corporation 401k account. So you can and you should deal with the market fluctuations on the one account that's being used to offset. So in other words, the ones that you've already equalized that are not being offset, you cannot attribute earnings and losses to those because that's already had a line drawn in the sand. Those have already been computed as of a certain date for equalization purposes to determine the 10,000 in my example. And then that 10,000, yes, that 10,000 can be and should be affected by market fluctuations or is not included or excluded, either way. But certainly you can't do them all. So you can draft up something that says the party shall equalize these accounts, list out the specific accounts. And if you've already done the calculation and know You say, and the 10,000 that is being equalized that came out due, the wife shall pay the 10,000 from XYZ ABC Corporation 401k, and that account shall be subject to earnings and losses from the date of signing this agreement or this date forward through the date of distribution. So that way, when we prepare the QDRO, we certainly can do that for you. But when we get agreements that say the parties shall equalize these accounts and all the accounts shall be subject to earnings and losses, that's actually an impossibility. So certainly want to avoid that. Now I know I talked a little bit longer than I wanted to about defined contribution plans. So, and I don't want to keep you here all day, but real quick, defined benefit plans. Defined benefit plans are a completely different animal. Those types of plans are where the employer, based on years of service, terms of service, age at retirement, the level executive that you are within the company, all these actuarial factors are used to calculate some defined benefit that you're going to receive at some point in the future. So the important thing to know is that when you're talking about equalizing accounts, you can't equalize defined benefit plans and defined contribution plans. Now, there are rare circumstances where that can be done, and only time that I've seen that done, again, very rarely, is if you take, the parties really want to leave each other's retirement account alone, and what they do is they take the defined benefit plan and they have a professional pension valuator value that to get that into today's dollars. So then they get the defined benefit plan and turn it almost into a defined contribution plan in terms of understanding the value in today's dollars, and then use that for either offsetting or something else. That's the only time I've seen it done, but as a general rule, equalizing defined benefit plans and defined contribution plans is a no-no, because they're two entirely different things. Defined benefit plans, like I said, the most important thing to take away from defined benefit plans is in an earlier video I talked about getting the survivor benefit or the summary plan description, because in defined benefit plans the biggest